proposals likely to damage a site of special scientific interest, which is the domestic law protection for sites which have interesting ecology or other features. And plans and projects likely to have a significant effect on any European site, and that includes special protection areas, which are created to protect birds and bird habitats, and special areas of conservation, which protect all other forms of habitat, or sites listed under the 1971 Convention on Wetlands of International Importance, so Ramsar sites. So that's essentially what we do. And we've just reorganized ourselves, and the purpose there was to push our resources out into local areas, into local communities, so that we can make better use of it. And as a result of that, we have this quite amazing organogram, which has emerged, which gives you an idea of the core issues that we deal with and the areas in which we work, and they're listed there. And this arrow here shows you where I am based. So I work within the executive office. And it's a very small legal team. There's only 4 lawyers. And we cover a large range of casework and a great deal of different statutory regimes as well. So, environmental law. And I think to start you off, I want to give you a conceptual picture, an image, to keep in your mind. And that is of environmental law as hot law. And that's a term that was used by Elizabeth Fisher in an article which she wrote for the Journal of Environmental Law recently. And she talks about environmental law being a polycentric, interdisciplinary, normative, and scientifically uncertain nature of environmental problems leads to a body of environmental law in which it can be difficult to settle on a single frame for understanding a problem, and thus to identify relevant parties and the relationships between them and the courses of actions that may be taken. And because of that, she talks about it being environmental problems being hot. They're not just controversial. Controversies are structural and foundational to environmental problems. You know, we should expect to see controversy when we're dealing with an environmental issue. And you know, there's difficulties in identifying the source of something, or target agents of something. There's a wide group of actors in environmental issues. And there's a lack of stabilized knowledge base. And mutually incompatible understandings of the world, you know, intrinsic difference of opinion on how we should be achieving the common good when dealing with the environment. And this makes it an area of hot law. And that stands in contrast to what most people have in mind when they think of law, which is a cold state of law, which is the kind of thing that persists with contract law, where everyone is clear on what the terms of that contract are. You work very hard to ensure that everything is on that document, there's nothing left to chance or outside of it, and no ambiguity, and everything is clear-cut. Clear-cut isn't something that is enjoyed in the realm of environmental law. And just to round that image home, here's a picture that shows the complexity of the ecosystem, all different inputs, and so on. And some of these ideas come across, you know, about the complexity of it all. And there's one quote from Lord Harthwaite, who's a judge who specializes in environmental issues in the Supreme Court. And he says that he was struck by the contrast between the relative simplicity of the basic objectives. We kind of know what we want to do most of the time, but the simplicity of the basic objectives and the complexity of the machinery by which we try to give them effect. You know, it is a very complex area of the law, and you know, I have great sympathy with people who do struggle with that. So science, then. How does science and the law work? Well, let's just talk a little bit about science, and I do approach this from the position of a novice. But the scientific method first. Here's Karl Popper. And Karl Popper said this. He was a philosopher who talks about science. And here he said, the game of science is, in principle, without end. He who decides one day that scientific statements do not call for any further test, and that they can be regarded as finally verified, retires from the game. And that was very much his approach. You know, that scientific theories exist until they're falsified by something else. that you just continue to push and push to test and test again the theories that you have. And it's an ongoing process. And quite frankly, I mean, that's part of the beauty of science. That is the elegance of science, is that it continues to ask these questions in a searching, probing way. And here's what most people have in mind when they think of scientists, although the scientists that I work with don't tend to look like that, but that's kind of what we have in mind. And so what do scientists do? Well, they hunt for error. They know that knowledge is tentative. They're 95% confident to something. There's no simple definitive answers. But the beauty of it is that the scientific method, the scientist, is continually working within environments in which things are falsifiable, they're corrigible, they're progressive by their nature. We're constantly trying to learn, to build on what we've got, to test it, and to make it go further. It is by nature reflective. It learns from what's gone before. We build up this store of knowledge. And a definition that I quite like is this one here: an interconnected series of concepts and conceptual schemes that have developed as a result of experimentation and observation and are fruitful of further experimentation and observation. It's an ongoing process, and and that's as I said, that's part of the beauty of it. And as Karl Popper said again, the history of science, the history of all human ideas, is a history of irresponsible dreams, of obstinacy, and of error. But science is one of the very few human activities, perhaps the only one, in which errors are systematically criticized and fairly often in time corrected. And this is why we can say that in science we often learn from our mistakes, and why we can speak clearly and sensibly about making progress there. So, having got a feel for what we mean by science, let's talk a little bit more about the scientific method. Well, at its core, at its bedrock, it is a rational form of analytical thinking based on logic, and that includes deductive and inductive forms of reasoning. Now, where knowledge is uncertain or incomplete, we can rely on inductive reasoning to help us make sense of it, and it's a valuable tool. It's a motor of development by using inductive reasoning. And then when we use inductive reasoning, the conclusion follows with a high probability from the information in the premise or the premises of the argument. That's how it works. And your classic inductive arguments are that A's are B's, C is an A, so therefore C is likely to be a B. Or, with a slightly pithy example, if most little dogs are yappy, if Fido is a little dog, or therefore Fido is likely to be yappy. So that's an insight into inductive reasoning. Inductive reasoning which is based on samples, and it relies on analogies or comparisons to reach a conclusion. And unlike deductive reasoning, where it's either sound or not sound based on the validity or the premises which inform it, inductive reasoning, well, it's either strong or weak based on whether the conclusion follows with a high degree of probability from the premises. And that's important because you can see from that it's inherently uncertain. It's based on these probabilities, and you are vulnerable then to this talent, black swan event, which questions those facts and changes our knowledge base. But it is also predictive in nature. It's not always easy to determine whether an outcome is or is not highly likely based on available information. But that's taken into account when we use inductive reasoning. We know that this is inherent within it. But that's how we apply rational analytic thinking when we have not a great deal of incomplete information. So, the role of scientists. So if uncertainty is a feature of the scientific analysis, when it's based upon inductive reasoning, well, then uncertainty, it just emerges in that context. It's a natural part of it. Scientific uncertainty is something that we have to live with. So what do we do about that? Well, scientists are duty-bound to demonstrate where there are uncertainties, of course. And those uncertainties can be lost when we oversimplify. The scientists that I work with are infuriated when debates, which they are closely involved in, which the research which they're providing provide, and in the debates that take place over that, they sort of generalize that, and these sort of nuances and subtleties are lost. And we know that we can't have absolute certainty. Rather, we have degrees of competence. A high degree of competence, moderate degree, low. And these are based mostly on probability. Like I said before, whether it's a strong or weak argument. And this is a quote that I quite like, and it's taken from the Royal Commission on Environmental Pollution, their 21st report, written quite a few years ago, but it kind of captures what I'm trying to talk about here, which is, and this is how they put it, we believe it is essential that environmental policies should have a sound scientific basis. There is, however, a widely held view, even expectation, that scientists can provide the answer to whatever issues are under consideration. Science is not a matter of certainties, but of hypotheses and experiments. It advances by examining alternative explanations for phenomena and by abandoning superseded views. It has provided very powerful tools for gaining understanding of complex environmental processes and systems. And at the same time, there are many cases in which damage has been caused to health or the natural environment because of gaps in understanding. Such incompleteness is inherent in the nature of science, especially environmental science, which deals with the world outside the laboratory. That captures where we're at, particularly with the stuff that comes across our desk, but naturally when we're dealing with impacts caused by major developments in the natural environment. So, scientific confidence and uncertainty. So what are the forms of uncertainty? And as scientists, you'll probably have a very clear idea on all of this. But we'll just dig a little bit deeper so you can see what kind of things informs, undermines confidence and can cause uncertainty. And those include value uncertainty, structural uncertainty, unpredictability. And the European Commission also gives examples of what causes uncertainty in their documents on this, and that includes the variables chosen, the measurements made, samples drawn, the model used, causal relationships employed, or controversy on existing data or lack of some relevant data. And this undermines certainty, causes uncertainty, but uncertainties which the good scientists must point out. This is an inevitable part of the work that we do, and we point it out when it exists. So much for science then. So how does the law try to accommodate this, respond to it? Well, one response that I particularly want to look at is this: reconciling scientific uncertainty in a legal framework. And that's the precautionary principle. That's one approach to this. That's the final one I want to talk to you about today. So what is the precautionary principle? Well, it has various roots in the law, but a particular starting point one seems to go back to is Principle 15 of the Rio Declaration 1992, and that said this: in order to protect the environment, a precautionary approach shall be widely applied by states according to their capabilities. Where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. I've highlighted that bit because that's what we mean when talking about this precautionary approach. And I should tell you now that that's recognized as a weak version of this, because it brings into it a cost-benefit analysis. There are stronger forms which do not do that. And following the Rio Declaration, well, the precautionary principle became incorporated under European law, and it exists under Article 191.2 of the Treaty of the Function of the European Union. And that says that Union policy on the environment should be based on the precautionary principle. So you can see that it's an emerging legal principle. And these are a reference point in law which applies in circumstances where there are scientific uncertainty. Now, I should just pause there to explain the difference between a precautionary approach and precautionary principle. So the the term precautionary approach and precautionary principle are used almost interchangeably, but there is a difference. Because when you invoke the principle, that suggests that it's a source of law, and therefore a tool, a legal tool for interpreting something which carries weight. And that's consistent with the way that the European Union uses it, particularly in this treaty context, so that it's essentially a part of the Constitution, which we operate in under at European Union law level and at member state level as well. And using the precautionary approach suggests that it's not a legal principle, and therefore that you can vary it at a local level. You can do a lot more with it, and you can take into account economic considerations and social impacts. So when you see the term precautionary approach used, it's generally meant as a softening of its implications. And of course, all of this has led certain commentators, such as Carl Sunstein, to criticize the precautionary approach and principle as essentially hopelessly vague. But aware of that, nevertheless, it is a principle in European law, certainly, which tries to deal with this issue of scientific uncertainty. So, the European Commission in 2000 provided a document which I partly suggest that you read. It's very interesting, in which they try to explain what precautionary principle means. Essentially it's this: it's the recognition of the fact that decision makers tasked with making decisions on health and environmental risks, and who can find the available scientific data contradictory or scarce, are permitted to apply the precautionary principle as a regulatory tool. And you can think of it like this: the precautionary principle is as a sort of a rational response to uncertainties in the scientific evidence relevant to environmental issues, and uncertainties about the consequences of action or inaction. And that is because even the best scientific assessments, in certain cases, may not provide a clear basis for decision-making on environmental issues. And as the European Commission says, the precautionary principle is considered within a structured approach, consisting of three parts: risk assessment, risk management, and risk communication. And they say, do not confuse the elements of caution that scientists apply in their assessment of scientific data, for prudential concerns about how a scientific experiment is set up, for example. Rather, the principle applies where essentially there's potentially dangerous effects deriving from a phenomenon, product, or process, and that's been identified, and that scientific evaluation does not allow that risk to determine sufficient certainty. But in honesty, and as the European Commission communication points out, the precautionary principle is essentially about risk management. It's about how you approach something in the context of a lack of information, essentially. So the European Commission says that, okay, well, so what do you do? Well, you start with a scientific evaluation, and you do that as complete as possible. And where possible, identifying each stage the degree of scientific success. So the good scientist, he points out the problems that exist, the uncertainties which lie there. And, decision makers need to be aware of that uncertainty that's attached to those results, and to reflect upon that when making a decision. But when judging what is an acceptable level of risk for society, well, that's an eminently political responsibility. And that's, formed out of thinking, what is an unacceptable risk in this context? What is the degree of scientific uncertainty? What are public concerns in this case? What are the public concerns? And they say it's a duty for decision makers to find answers to this question and to reflect on that. And they also say that decision makers that the precautionary principle will be fleshed out by the application of it by decision makers and in the courts as well. And that the scope of the precautionary principle will depend upon trends in case law and be influenced by prevailing social and political values. And they say that analysis of the precautionary principle reveals two quite distinct aspects: the political decision to act or not to act as such, which is linked to the factors triggering the course of the precautionary principle, and then the affirmative how to act, i.e. measures resulting from the application of the precautionary principle. So I think what you get a feel from here is that we know that there is uncertainty in certain areas, we carry out a scientific assessment, we study that, we point out those uncertainties. That's perfectly, that's the perfect starting point. But there is then this realm of value-led decisions which are carried out in a political context. And you see this sort of two-step process that's at play here, which is incorporated in the application of the precautionary principle. That there's an element of political discretion. And that's quite important. You will see that then as a trend throughout the environmental law the field in which it applies the precautionary principle, and I'll talk about that in a moment. And the Commission also says that there should be various principles which underpin the application of the precautionary principle, and those are these, and I'll chop through them quite quickly, that they should be proportional, aiming measures that shows level protection, they should be non-discriminatory, they should be comparable to situations before you shouldn't treat things differently, that they should be consistent, so measures should be of comparable scope and nature to those already taken in their equivalent areas in which all scientific data are available. They should be based on comparisons of the risks and benefits associated with various possible alternatives, both in the short and long term. And they should be subject to review in light of new scientific data. They should be capable of assigning responsibility for producing the scientific evidence necessary for more comprehensive risk assessment. Of course, they should be transparent. It's important that they are, so that people can see the basis on which decisions are made. And also, they say the burden of proof is with the applicant, with the person trying to put forward the harmful development or the product which could put people in the environment at harm. So how is this considered in case law? Well, a key case. Oh, sorry, I should also mention that yes, it's ultimately political responsibility. So how has this been looked at in case law? Well, a key case on this is the Pfizer case, and that was where there was a challenge to the lawfulness of EC Regulation 2821/98, which placed a ban on the use of a number of antibiotics as additives in animal feedstuffs. So this ban was imposed on the ground that there was a risk that the resistance to these antibiotics which animals might develop could be transmitted to humans once the animals entered the food chain. And that was heard by the Court of First Instance, which is now called the General Court, which hears these sort of disputes of a technical nature. And, unsurprisingly, the precautionary principle was a key determined principle in that case. And that said this, that the precautionary principle applies in situations of scientific uncertainty when a risk assessment cannot provide decision-making with conclusive scientific evidence, as we've just been talking about. It confirms that in case law. So you can take preventive action without having to wait. But it cannot be based on a purely hypothetical approach to risk, founded in mere conjecture, which has not been scientifically verified. It must be backed up with the scientific data available. There must be a scientific assessment that starts it. So you can't just say, oh, well, there might be a problem. You need to have something more than that to tip the scales into this realm. And we also importantly acknowledge that there's no zero risk situation. You don't have to establish absolute positive proof of absolute safety, because that's just not realistic. This issue as to what constitutes plausible risk is very, very interesting, and I'll talk a bit about that later in the context of the Habitats Directive, which is the area of law that I work with on a daily basis. But what is a plausible risk is a hugely contentious and endlessly fascinating debate, and it's one that's been looked at in case law, and for a case that follows after Pfizer, you can see Commission in Denmark 2003, which talks about plausible risk. In the Sweden Commission case, again a European law case, a general court refers to the existence of solid evidence which, while not resolving scientific uncertainty, may reasonably raise doubts as to the safety of a substance. So there's got to be some identifiable cause of concern in order for this precautionary principle to be invoked. So some reflections on the precautionary principle. Well, it's very complex. It's essentially about procedure. It's really a procedural thing. It's about doing things within a process. It's acknowledges the fact that facts alone cannot justify alone don't justify a decision. It creates a space for non-scientific arguments to inform the debate. So you do a scientific assessment, but then also there's an acknowledgement of non-scientific arguments being important when making a decision. And that raises questions about the values of decision makers, whether it's part of the political process and involving democratic deliberation in it. And this reflects very much the European Union's approach to environmental law, which separates out facts from values in decisions. So it creates space for environmental law policy for expertise, for technical expertise on something, and then, having done that, you go into the political realm, political responsibility for decisions. But are these two fields kept separate? Well, no. There are huge tensions between the two, and political considerations can reach into the scientific assessment, or a purely political decision on environmental impact is dressed up in the language of science to give it some sense of legitimacy. And that's something to be aware of and to be vigilant of. So I'm going to look at this, the application of the precautionary principle in relation to the case that we do. So National England is especially constantly on the application of the Habitats Directive in UK law. The Habitat Directive protects certain habitats from destruction. And the leading case on the interpretation of the Habitats Directive is the Broadbent. Now, with less than environmental law, the work that I do, that we have this leading case which tries to explain how the various different parts of the directive are explained, because European law is hopelessly ambiguous in the language it uses, probably because it has to be translated into lots of different languages. So certain terms need to be teased out in case law, and luckily we have Broadbent which helps us with that. And there are various stages to this, and this should now become familiar to you, having just discussed this. So first of all, you think, okay, well, is there a likely significant effect upon a protected site caused by something? So there must be an appropriate assessment, and on the basis of objective information, it can be excluded that the plan or project will have a significant effect on the site, either individually or in combination with other plans or projects. That's a very low threshold. You've got to be able to exclude it. And if you can't exclude it, well then, how you go and make sure if there's a problem, you do that by carrying out an appropriate assessment, which identifies every aspect of it using the best scientific knowledge in the field. But there can be, but using the principles talked about in advice about there being no zero risk, there's got to be a plausible reason for there to be a plausible problem that requires consideration, and that's been looked at in UK domestic law. So, for example, in the Hart case, it was stated that merely expressing doubt without providing reasonable objective evidence for doing so is not sufficient in order to invoke an appropriate assessment. And in the Boggess case, it's got to be credible evidence on real rather than hypothetical risk. And in the Bateman case, which is 2011, Justice Moore-Vick said that what was required was more than the bare possibility, though any serious possibility would suffice. Those are very difficult and quite subjective terms to tackle, but it gives you a hint of this debate over whether there's serious risk or not. So having carried out the appropriate assessment, we'll then move to see whether there's an adverse effect on integrity. And here Broadbent is very, very strict. It says the competent authority must be convinced, certain, have made sure that the scheme will not adversely affect the integrity of the site. And that's very difficult. We talked about scientific uncertainty. You can't be absolutely sure. It's very hard to do that. But it says, if it looks like there's a problem and you've assessed it, then you've got to be convinced there's not going to be a problem. If you can't be certain, then you can't give permission for it. And a term it also uses is no reasonable scientific doubt remaining, and that's the term that my colleagues are more comfortable with. That's the formulation of this test, which they are happy with than the others. But they mean the same thing. But here comes the political part of this. if you find that you can't be certain there will not be a harm caused to the integrity of the site, you can still permit the development if there are no alternatives. It can't go anywhere else. It has to go from this protected site. And it's required for imperative reasons overriding public interest. So therefore, basically, it's for economic and social reasons, it's imperative that we have this development. So the political decision can overrule. So that's a trot through how the law has tried to incorporate, has tried to reconcile science, has tried to fit it within a framework, and it's done so within the precautionary principle. And I'll just quickly give you an overview of other approaches to regulation, environmental law and policy. And I thought I might do that by providing this table here, which kind of gives you a nice overview. So there are various approaches to regulation in environmental law, and to be honest, they come in and out of vogue depending on the sort of political climate. The first that was used was very much command and control, which is a derivative term used for sort of direct regulation. And that was associated with the rise of environmental law in the 70s, where there was a feeling of crisis, that certain things had to be addressed, so levels of chemicals in water supplies, for example. And so direct legislation was made to bring those levels within what was found to be acceptable. Following the 1980s and sort of the rise in neoliberalism and so on, that was seen as unfashionable, so different approaches have been used, and that includes, for example, procedural, flexible, experimental, governance-style approaches, where there's like a framework, directive, when you sort of talk about, you create a space in which environmental issues are discussed and dealt with. That's very much the approach now of the European environmental law, dealing with problems. But there are other forms as well. So one is reflexive approach, so voluntary mechanisms, so self-regulation, so labeling things, to give consumers an idea of their environmental impact. That is actually a very powerful tool, particularly in the marketplace for causing environmental regulation. And also, because we now live in a neoliberal world, based upon the logic of markets and efficiency derived from markets to bring things about, but also economic instruments as well, which try and harness that. So you have emissions trading schemes, for example. Which have worked to varying degrees of success. And what you'll find is that some bits of legislation will snatch from different areas of this. So you'll see the Water Framework Directive is primarily a procedural-led, flexible, experimental type of legislation, but it contains some pretty hard command and control aspects to it. It also contains some pretty reflexive voluntary mechanisms as well. So you can mix and match. But these are conceptually, these are the main sort of approaches to environmental regulation. And talking a little bit about the Water Framework Directive, because it's so interesting. So just drilling down a little bit to the Water Framework Directive. So the Water Framework Directive was in response to the Sandoz spill in 1986 in Switzerland, which chemical spill into the Rhine, which wiped out the ecology of it to a large degree. For example, it almost entirely killed the Rhine eel population. And the difficulty there was that the Rhine passed through various different jurisdictions, different countries. And so having a combined approach to the protection of the Rhine was seen as important given its transboundary nature. And so this kind of led to the Water Framework Directive. And the Water Framework Directive tries to seek good ecological status for water, and that's interesting. It's quite aspirational in scope. In fact, its scope is huge. So it doesn't give a detailed standard which water needs to reach, but in river basins, but rather sort of notion of good ecological status. And that means that the chemicals in it must be addressed, and that's your very strong command and control element to it, but also the ecology must be good. And that's something new in the Water Framework Directive, that it sort of puts it from an ecological, holistic view. So it's the capacity for the rivers to support life, and for it to flourish, is what they're looking for. And it consists of these river basin plans. Those river basin plans can cut across boundaries. So you're not looking just at the bit of the river that passes through your country or through your county or whatever. It's about looking at the river basin as an ecological unit in of itself. And that's a very interesting move in environmental law. It's based on this notion of intercalibration. So you talk to other people in the European Union about what their river status is like, and you try and calibrate. So you're not trying to get the same level of protection across rivers across the European Union, but the sort of relative protection through this process. There's a massive scope for public participation in all of it. There's sort of move to polyphonic federalism, as the European Union likes to call it. So you bring in people, and that's really to address a feeling of a crisis of legitimacy in European Union law. That you can't, the European Commission, feels conflicted about directly regulating people, given that there's a democratic deficit in the way that legislation is put together. And so what you do is you create procedural rights for people to get involved in the process. That's what this legislation does. It's reflexive, iterative, it learns from what it produces information, constantly creates new river basin plans over time, and it learns from that. And there's an argument that it is just a talking shop, that all you do is talk. There isn't enough being done to directly tackle environmental problems. But then some would argue that there's strength through flexibility as well. Another hugely important area of environmental law that I should mention, and it builds upon this notion of public participation, is the Aarhus Convention 1998. And there was Kofi Annan, who was Secretary General at the time, and he says the Aarhus Convention is the most impressive elaboration of Principle 10 of the Rio Declaration, which stresses the need for citizens' participation in environmental issues and for access to information on the environment held by public authorities. And as such, it's the most ambitious venture in the area of environmental democracy so far undertaken in the auspices of the United Nations. That's kind of what they're getting at, environmental democracy, creation of responsible environmental citizens. And you do that by giving them this. You give them access to information, you give them access to justice, and public participation as a key aspect of environmental decisions. And a large part of what we do in this organization is deal with that. Half our team deals with access to information requests that were made in national laws. You want some information about this decision that you're making, all of it, and we have to provide that. And also defending ourselves against judicial review claims brought by people who dislike the decisions that we make in certain areas. The convention is something that has teeth because it's been incorporated into European Union law. And just earlier this year, in February, there was a case, Commission versus the UK, where the UK was found to have failed to comply with European directives implementing the Aarhus Convention because of a lack of protection against judicial proceedings being prohibitively expensive. So the legal system in this country is very expensive, and there was a lack of protection for people in terms of protective cost orders if they wanted to bring a case against a decision maker. So we had to change our cost protection regime in order to reflect that. And there are various other examples as well of environmental law, and I'll just go through these quickly, but those include environmental impact assessment or strategic environmental assessment, which is aimed at generating information. So if there's an impact upon the environment, you create lots of information within the environmental statement. You draws it all together. And the idea, hope, is that by doing that, it makes the decision which is made then transparent, and because the public has access to these environmental statements, that they can get involved in the decision making. That said, though, these documents are often incredibly technical, incredibly lengthy, and it entirely puts members of the public off. The Environmental Information Regulation, so as I was saying, access to information being absolutely key in this legislation gives people the right to ask for environmental information. And there are other framework directives as well. So the Marine Strategy Framework Directive, which builds on the Water Framework Directive principles. So it takes that model of creating this framework based on an ecological unit, like a river basin. Here we're talking about it's in a coastal setting, and it tries to incorporate an ecosystem approach and sustainable use of marine resources, as well as greater cooperation at EU level and greater levels of public participation. So there are great strides in that, and as I said, that's very much the mould in which very ambitious bits of environmental legislation are made in. So finally then, some personal reflections on what all of this means. And here I got a couple of quotes from Lee and Holder who talk about science and the law. And they say this: science has a central role in legitimating environmental law and policy. An appeal to facts, as established by science, is used to preempt and undermine criticism, although there are inherent difficulties with relying on science in this area. The apparent objectivity and testability of science, seemingly above the fray of divided interests and political advantage, can be extremely attractive to politicians and lawyers. And that's very true. It can be used to dress up a decision which can be primarily political in nature. And they say, notwithstanding the acknowledgement of public values, the temptation for final decision makers to seek refuge rather than enlightenment in the scientific and technical discourse, such as risk assessment across medical matters, is great. And the challenge is to ensure that technical information is used in a way that informs rather than usurps political decision making. And when I talk about political decision making, that's not a bad thing. It's entirely legitimate that should be that process. But I think what I'm driving towards, and which I'd like to leave you with as an idea, is that there should be a clear separation between the scientific risk assessment, scientific assessment that's carried out, and the risks of the impact that may occur, the technical exercise. But then there's also a division between that and the decision that's based on values and politics, which then flows from that. So my own view is this, that science should, of course, form the evidence base of decisions. But there's this realization that it alone isn't enough to make a decision. There are deep moral and ethical issues which are an inevitable part of environmental decision making, which requires a discussion of values, and done so in a political context, which relies upon people participating in the process. And that makes space for a wide appreciation of the environment and our participation in it. Genuinely making space for public participation in environmental decisions. But in the knowledge of this tension which exists between the need to govern and make a decision in something, and the need to involve the public in that decision. And that tension is a good thing, because it might drive people towards being actively involved in environmental decisions. Arguably, this is what we want. We want a society where there are active environmental citizens. They're forming the sort of world that they want to see. And the law does create a space for that. These primarily procedural rights, which are provided for under the law, create the space that people can do that. But too often you see people turned off the process, particularly when it gets too technical. There's a feeling that they can't voice their concerns. And these tools which exist for public participation are not used effectively. And a large part of the debate, I feel, should be based upon how we should use the environment. What should our approach be? And that's about trying to keep this balance between using the environment for the resources that it has, but also making sure that our use of it is not done in a way which abuses it as well. And so trying to strike that balance and doing that within the context of the law which does not make people good, but rather reflects how society wants to approach a problem. To have a good debate which talks about science and the pinning a decision, talks about the uncertainties of that science, and then talks frankly and clearly about the values which are used to inform it. And so that you can move away from this place where science is used to dress up a primarily political decision, or politics leaks into what should be an objective scientific assessment. And I think that's the message I'd like to leave you with as a result of this discussion today. So thank you very much for joining this webinar and for listening in. I hope that you heard most of that okay and that the slides work. My email address is there. I would love to hear from you if this is a topic which does interest you, something that you may have thought about before in the past. And if you have any questions, I think there's a few minutes left, so feel free to send those through to me and I'll try and answer them as best I can. But thank you so much for listening to this webinar today. Thank you.
Thank you so much, Richard. That was really fascinating. Yes, and as Richard says, everyone, if you were to pop your questions in the chat box or the question box at the side, then I can put them to him. Whilst you were talking, Richard, we did have a question which came through. Ronnie Palmer was asking if there was a test of reasonableness where scientific uncertainty is concerned. For example, no reasonable scientific uncertainty remaining. I think you addressed that in one of your slides.
Absolutely. That's a great question, and one which it's, as I said to you in the extracts from the case law, it's something that has been debated. There's got to be some, that you can't just express doubt. There's got to be a reasonable objective evidence. There can't be a bare possibility. There's got to be a serious possibility. What does this mean? It's very difficult to say in general terms. It will turn on a case-by-case basis. But, and I said about this sort of bleeding across of the two things, where political priorities can move into the scientific assessment. What can happen is a decision maker will say, well, I find that this level is acceptable, and therefore it doesn't tip the scale. There isn't a problem that needs to be investigated. And I think what scientists should do as statutory advisors, especially as a statutory advisor, is that we should say, well, look, here's what the science tells us. Here are the uncertainties. Look, it's a range. It's a range between these 2 points. Where on the range you fall, where you think it's acceptable, well, that's for you, decision maker, based on what you think is an acceptable level of risk. And there will be disagreements about that, but the courts are unlikely to overturn a decision which has had good regard, full regard to the information provided to it, because so long as it's done that, then that is a rational decision in itself. And a court is not going to step into the shoes of a decision maker and say, well, you've gone for there on the range, but you should have gone here. Hope that answers your question.
Great, thank you, Richard. Lots of people are asking if the presentation will be available on the IES website, and it will be afterwards, as long as Richard's okay with that. We've recorded this one, and Richard's very kindly already done a version of this. So I have another question for you, Richard. This is from Adam Donnan. Businesses discuss their appetite for risk with their board and investors and then come up with a discount rate for the organisation. Should politicians work out a risk appetite with their constituents, and could you then build that back into the decision making in some sort of consistent framework?
Well, that's a very good question, and I think at its core it's about how you determine what are the values which should be applied in a particular context. And during the presentation, I quoted the 21st report of Reset. And if you read that, it's online, and do read it. It's very interesting. It's written in 1998, but it's well worth a read. But in that, it says, well, how do you take into account values? What processes are there? And it comes up with a list of them, and it says, well, you could seek public opinion surveys, you could have consultation exercises, you have public inquiries which involve the public, you have parliamentary procedures as well. where Parliament itself can ask questions or seek, ask its constituents what the advice is. Those are all very good things to happen, and the conclusion of the report was that those absolutely should be used, and should be used at an early stage in decision making. If you don't do it at an early stage, well then people feel there's a lack of trust from the public. They feel that their values haven't been taken into account in a particular form of environmental regulation. But it comes back to this. You need to have a good environmental debate in order to do this, a debate which people are engaged in as active environmental citizens, and which is friendly towards them, brings people in, it's accessible. And we've done great strides, for example, in providing technical information to people in form of environmental statements and so on. But increasingly we find people are turned off from the environmental debate because it quickly escapes into technical language. Technical language in order to sort of try and legitimate it in a way. And it should be a bit more accessible, I think. And I think perhaps by focusing in on values, that might be, it might become a more attractive debate for people to participate in.
Okay, great, thank you. And we have another question from Christine Braben. How does uncertainty, as discussed, feed through into the democratic and legal discussions, given that there are many complete unknowns, for example, chemical transformation rates in specific processes, which require a statistical literacy which can cope with very high uncertainties?
Oh, absolutely. Well, I mean, that's essentially what this law, this legal framework tries to do. It tries to carry out the scientific assessment, look at that, and then make a decision, a political decision based upon it. So that's how the Habitats Directive is framed. If it looks like there's any slight hint of a problem, right, carry out an appropriate assessment, thoroughly investigate it, and go on the decision on whether there's going to be an impact upon it. So that's how the law tries to approach it. But what you can find is, in fear of saying we just don't know, it's uncertain, there's a lack of knowledge, you'll see the language of risk assessment used in a context where it's just not appropriate because we don't know the probability of an impact. We don't know the magnitude of the problem. And there's also arguments over whether that is a problem anyway in the first place. And what you do say, I've seen it myself in public inquiries I've gone to, is an over-reliance on the language of risk assessment in a context where it's just not appropriate. And I think that there should be more clarity in the way that we talk about scientific uncertainty and just point out, look, here are the unknowns. That's not a problem. That's just an inherent part of this process, particularly in the environmental, in context of the environment where there are so many unknowns. And do that in a very transparent way, and I hope that that will better inform decisions and people's understanding of those decisions.
Absolutely, great. Okay, well I think that's all we have time for. So thank you again, Richard. That was very fascinating. And as I said, we will have all of the slides available for everyone on the IES website. But on behalf of all of us, thank you so much, Richard, and thank you to everyone who's taken the time to listen in as well. And we hope to see you all again soon when we do our next webinar.